John, we're ready. If you can start our recording. Thank you. Good morning. Today is Wednesday, July 10th. This is the regularly scheduled Collection Service Board meeting. My name is Roxana Gamusio. I'm the Executive Director with the program. In order to start business, I will go ahead and start by roll call vote to our members. Thank you all for being here. We have everyone in the room, so it is wonderful, wonderful to have you back, Lori, with us. You can let me know that you're here. We'll make sure then to get started. Lori Hadwig?
Here, present.
Thank you. Chip Hellman?
Present.
Thank you. Jason Hill?
Present.
Thank you. Greg Zaworski?
Here.
Thank you. And Tony Zikovich?
Present.
Thank you. We have all our members here. As the first order of business, just to rectify, the notice of this meeting was posted to the Collection Service Board meeting, including the date and time as of July 14th, 2023, when the dates were approved, and then today's agenda was posted since July 2nd. The first order of business we need to address is approving the agenda. If there are any changes, please let me know. Otherwise, we would need a motion to accept.
Second.
Thank you. We have a motion by Greg and a second by Tony. All in favor, please say aye.
Aye.
Aye. Any opposed, say no. Thank you, members. You have before you on your iPads the April meeting minutes, and if there are any modifications or corrections to be made, please let me know. Otherwise, we would need a motion to approve the minutes from April as presented.
I
Motion.
move. Tony moves to approve the minutes. I'll second.
Thank you. Motion by Tony, second by our chair, Chip Hellman. All those in agreement, please say aye.
Aye.
Any opposed? Hearing none, that is accepted. The next item on our agenda is part of the director's report. And if you'll turn to page 19 on your iPads, this is our financial document. We have, as of the May 2024 numbers, we're reflecting a deficit of $88,508. This will leave our reserve at $826,215. This is informational, but of course, nothing new. We're going to finish this fiscal year with a deficit, and just part of the trends with our companies. Nothing has changed. We're still seeing the most of the companies renew, but those that are consolidating, of course, we're losing licensing. So just something that in the next year we'll probably have to discuss and see what other ways, we can address. One of the items that the board is going to look at today is maybe addressing through the complaints process some reduction in legal fees and cost backs from the RP complaints division, and anything else we can look at.
Good.
The next item is the presentation for the 2025 meeting dates, members. If you'll take a look at page 20, this is the proposed dates based on what we currently do, which is meetings at 9:30 on that Wednesday. If there are any changes, you can address them now or send them to me, but otherwise, the dates as presented would be January the 8th, April 9th, July 9th, October 8th for 2025. So if there are no changes, I would need those approved to update our website.
Any changes, folks? You see anything there that causes any heartburn? Do we need a motion to approve those dates?
Yes, sir, please.
So moved.
I second.
Thank you. A motion by Chip and a second by Jason. All those in agreement of approving these dates as presented, please say aye.
Aye.
Any opposed? Hearing none. Thank you. The next item is an interesting one. This is something that we discussed at the last meeting, and so we can definitely stay here for some conversation. This is the proposed agreed citation guidelines. It's a 2-page document. I'll make sure that you have a minute to review. Joseph and I worked on the document. It is basically a process with which we've taken the main type of complaints that we see and proposed what the recommendation to close the complaint would be. And so when these complaints come in, because collections is a little bit lengthier, most of them are coming from consumers or other industry participants, It's very likely that Joe will still need to do a quick recap to determine where it falls, but we'll kind of work that out. And if the Complaints Division can do it, then they would be able to. But it would take the recommendation that's on the far right, as stated, that way we're consistent with what we do, and they don't live as long in the system, so they'll be closed out faster for the person that's filing the complaint, hopefully save us some time and some money to the program. So if you have any questions or changes you'd like to see, this would be the time to address it. Otherwise, when this is approved, you'll notice, hopefully by the next meeting, that reduced number of complaints and us moving through following this guideline.
Just give us a second.
Absolutely. Take your time.
And as you pointed out when I first got here, our legal report today is really long, 39 cases.
Yes.
And so some of those would go away with this because you would have the authority just not to have to come to the board. You would just issue.
Exactly.
First offense or second offense, and then.
Right.
then-
Exactly. So easily 50% of what was shown today would have fallen through this agreed citation process because there are 39 cases, but all with similarities and closures.
And again, these would be Sorry about that. Good morning, board members. Again, the agreed citation process is ideal for cases that are very straightforward. If there's questions, if there's evidence that needs to be produced, if there's something else that needs to be fleshed out, that's still going to come to me. I'll make sure that we have all the documentation to determine what or if anything did occur. But again, on something that's just very basic on its surface, this would reduce costs because essentially the staff would be able to evaluate it and then quickly close the complaint or issue a set amount violation, and then it'd be closed as opposed to being referred to legal, reviewed by legal, billable hours attached to it, X, Y, Z.
So I feel like this board's come a long way. You remember when we used to,
Have them come in.
yes, and we went through every single, it took a while. I really personally like this. One thing I notice on here, if we look at it, the very first complaint, we don't have to look, but the very first complaint on your legal report discusses failure to honor a disputed debt through the credit bureaus. Right. I think that's right. It may not be the first one. Someone disputed a debt and the collector refused to remove it or mark it as such with the credit bureaus. Is that right? In any case, even if I'm wrong about which case it is, there's nothing on here about that process, right? In terms, do we get those very often, I guess is what I'm asking.
So there are quite often debt disputes, but we don't have jurisdiction over the dispute of itself. So the amount or whether or not this is owed, it would just be simply the practice of, hey, this consumer has disputed it to you, so you needed to update with the credit bureaus
Okay.
that it's disputed. So it would just be their act, not like a flushing out of the debt in and of itself.
Okay. So I guess thank you. I think all this blends together because when I read that complaint, and I just read it today, but I thought, do we really have jurisdiction over credit reporting? And I think what you're saying is no.
We don't have jurisdiction over like the amount of the debt reported, but the rules of the board do require that upon a consumer's dispute of an account, that the credit service update the consumer bureau that the account is disputed until an investigation occurs, and then it's validated.
So now I'm back to this. If a company doesn't do that and egregiously refuses to, is there something we could build in here so you could just handle it?
As of now, that specific violation would come to me because that would be communicating false information to a third party. That would be how it would be assessed underneath
Okay.
our rules, and then that would be an evidentiary analysis for me to break down. I think that would be a little more complex than just have sent right back out the door with the agreed citation, because there's a knowledge element there. The collection
Okay.
service had to know that either a dispute occurred or that the information was incorrect when it was reported to the third-party consumer bureau. So
Okay.
that's why it would want to come in front of me. If that
Okay.
makes sense.
That's fine with me. I like what we're doing here. Give a little bit more authority to the people reviewing these every day.
And just to add, so the document, 6 months down the road or next year, maybe after 2 or 3 of our meetings, we could add a violation if the board is inclined and says, okay, this now trend has increased and we're always doing X, Y, Z, and we would add to it. Right now, we've got the 6 main points
Yeah.
back to Joe's explanation, but we could add and change it as we see that there's a different need.
Good. So I suppose you'd like a motion, a second, and a vote on this, right?
Yes, sir, please.
Lori, would you like to make the motion? You don't have to. Somebody else can. I'm sorry to put you on the spot.
I move that we accept this,
Okay.
I second the motion. How's that?
Perfect.
Thank you. We have a motion by Greg and a second by Lori. All those in favor of approving the agreed citation guidelines as currently provided, please say aye.
Aye.
Any opposed? Hearing none. Thank you, members, and thank you, Joe. We will proceed with training and move this forward immediately. Thank you.
Perfect.
I will turn it over now to our legal counsel, Joe, who's done an outstanding job with the 39 cases. Joe, it's all yours.
Good morning, board members. You do have the legal report in front of you. As Roxana just mentioned, there was quite an uptick in the complaint numbers. Just for your information, I looked back at our last 2 meetings, so this would be January and April. January, we had 24 complaints. April, we had 23. This complaint includes 39 total complaints, 38 new. There is 1 representation based off of new information supplied by the respondent on this report. That is the last one. Of these complaints, I will say there has not also been an uptick in discipline. So the vast majority of these cases, I've recommended closure based off of those facts. So it's not as if the program is seeing a equivalent increase in violations as opposed to the increase in complaint numbers. I think just due to general factors in the world today, we're seeing more of a nature of consumers filing or pursuing actions with complaints as opposed to direct communication with an opposing party or something like that. Now, that is a presumption on mine, but that kind of explains why closures are increasing as opposed to violations.
Good.
So please review the legal report. I'm more than willing to talk on any cases or address any issues that you see. After the legal report, I do have a couple of revisions to the rules that we discussed at our last meeting to quickly bring up. And then, Mr. Hellman, you also asked me a question about assignments and Tennessee's laws on assignments at our last meeting, and I have the statute and the answer for that, so I'll address that last after we go through the legal report and rule
Perfect.
revisions.
So would you guys like some time to review, or did you do better than me and review this on your own time?
Yeah, I reviewed it last night.
Do you have any questions for Joe? I don't think there are any questions, so I think we need to read the cases into the minutes, right? How we normally do, and then, Greg, do you have anything?
no, I don't.
Okay.
I looked over them last night and,
Okay.
in agreement.
Okay. Thank you, board members. I'll go ahead and read the complaint numbers into the record. Complaint 202-4006111. Complaint 202-401-7011. 202-401-2891.
Can you stop for just a second?
You're on page 25.
Okay,
Page 25 of the iPad.
great.
Thank you.
Keep going. I was looking
Did I
at
just read it
last
before?
meeting's legal report.
Okay.
That got me too.
Okay.
Complaint number 3, 202-401-2891. Complaint number 4, 202-401-2901. Complaint number 5, 202-402-0801. Complaint number 6, 202-401-4381. Complaint number 7, 202-401-5341. Complaint number 8, 202-401-5571. Complaint number 9, 202-401-8671. Complaint number 10, 202-401-8781. Complaint number 11, 202-401-5151. Complaint number 12, 202-401-6121. Complaint number 13, 202-401-8231. Complaint number 14, 202-401-8691. Complaint number 15, 202-401-9221. Complaint number 16, 202-401-9411. Complaint number 17, 202-401-9631. Complaint number 18, 202-401-9901. Complaint number 19, 202-402-0771. Complaint number 20, 202-402-0971. Complaint number 21, 202-402-1181. Complaint 22, 202-402-1231. Complaint 23, 202-402-5591. Complaint 24, 202-402-1561. Complaint number 25, 202-402-2431. Complaint number 26, 202-402-2971. Complaint 27, 202-402-3581. Complaint number 28, 202-402-6031. Complaint number 29, 202-402-9761. Complaint number 30, 202-402-7271. Complaint 31, 202-402-4631. Complaint 32, 202-402-1071. Complaint number 33, 202-402-6341. Complaint number 34, 202-402-7871. Complaint 35, 202-402-9561. Complaint 36, 202-402-9581. Complaint 37, 202-403-1481. Complaint 38, 202-402-8851. And then complaint 39, 202-305-9451. Those are all the complaints on this legal report for July 10th, 2024. The next matter that I wanted to discuss with you all are 3 revisions that have been made to the rule. Oh, I'm sorry, jumping ahead.
We need to approve the legal report. Do I have a motion? Oh, go ahead, Greg.
I'm going to recuse myself on this vote because one of the complaints involves my company.
Okay.
So I'm going to recuse myself.
I think
Does
that's,
that work?
I think,
Yeah,
Yes. We still have quorum, so that is fine.
okay, good.
Yes.
good, all right. So Greg is going to abstain, but do I have a motion to approve the legal report? Okay, second?
I second.
Okay.
Thank you. We have a motion by Jason and a second by Tony to approve the legal report as presented by Joe. All those in favor, please say aye.
Aye.
Any opposed? Hearing none.
And of course, I'm sure the minutes will reflect, as it should, that Greg
Yes, that
abstained.
Greg has abstained. Yes, sir.
Okay,
Thank
good.
you.
Thanks.
Thanks, Chip.
Okay, on to our next matter of business, rule of revisions. As we discussed last time, the Department of Commerce and Insurance last year conducted a retrospective review of all of our program's rules, the laws on the books, and basically looked for any discrepancies where a law had changed and a rule no longer reflected something. Also, we looked at organizational issues. Were there ways that we could clean up the rules to make them more formatted and more logical based off of the writing and where things were located? For this program, the vast majority of the retrospective review was just cleaning up language or reorganizing the placement, for instance, of prohibitive practices is now essentially in false or misleading representations. Based on the rules in which you will formally approve the rules at a rulemaking in the future at one of our future board meetings, so there's no official approval of anything, but just to keep you updated, the legal department has reviewed those rules. 3 revisions have been requested. I wanted to update you on those revisions, and then we will pick back up the formal approval basis of these rules just so that the board is fully informed on everything moving forward. The 3 suggested revisions to the rules is one of the rules amendments we talked about last time was removing language regarding individual licensees. Agreed that it is very unlikely, or the circumstances would have to be very odd for an individual to operate as a collection service, but with the way that the statute is written, 62-20-102 provides the definitions of the statute. Underneath those definitions of collection service and the term person, it is still theoretically legally possible that someone operate as a collection service as an individual. Now, is that likely? No. But because the law is written in such a way, we've removed the repeal of the rules that reference an individual applying for a license. So that's the first revision that we've made since.
Okay.
The second revision is within prohibited practices in our rules. It states that a collection service should not state or imply that they have a legal department or affiliation. A lot of our licensees have a legal department built within their company or a compliance department where they may employ an attorney or legal representation. The statute states simply, and this is 62-20-120, that licensees cannot commit unauthorized practice of law. That is not strict enough to prevent licensees from having legal departments or compliance departments, and that's why they've instituted them. So essentially, the prohibited practices list is being moved into, as I mentioned earlier, false or misleading representation. So still staying intact, just being moved somewhere else. And then number 4 states that they can't have a legal department or affiliation. Since that's no longer representative of the industry, we're going to go ahead and remove that rule. And basically, companies can still operate as they have been with a legal department. I think it's a
Okay.
relic of an old rule. So that's the second revision to that rulemaking package we discussed last time. And then the third one is one of our rules, as it currently states, a violation of the rules will be deemed a violation of the rules. I think what the intention was and what legal department has essentially moved forward with the operation is that the board will deem a violation of 12 CFR section 1006 regulation F, which is the implementation of the Fair Debt Collection Practices Act. And essentially, the way that the rule is being proposed moving forward is, hey, if a licensee is found guilty of a violation of the Fair Debt Collection Practices Act, we as a board would then assess that violation as a violation of our rules, because our rules mirror the Fair Debt Collection Practices Act. So instead of saying a violation of our rules would be a violation of our rules, it's more logical in saying, hey, if a licensee violates the Fair Debt Collection Practices Act and they're found guilty on that in that appropriate court and venue, then we would be informed, and that would also be deemed a violation of our rules. And the licensee would look at discipline underneath your jurisdiction as well, because our rules mirror the Fair Debt Collection Practices Act. So that's the third suggested revision. We're just switching around that wording so it's more logical. But those are the 3 revisions since the last time we spoke. I'll go ahead and turn off my mic, open up the floor to you all for any questions on those 3 issues.
I don't think I have any questions, but my understanding then is that a future meeting, perhaps next, but maybe not, you're going to bring us the full
We call it a
complement.
rulemaking package. You will see a red line of the rules, the old rule,
Yes.
edited, new language, and then you will see a printout of the non-red line, which would be the new rules as published to the public. And that's when you would be able to review every single word and then suggest your revisions, and then I would bring that back into the formal process.
So these are not in the book today? Yeah,
No, they are
right.
not.
Gotcha.
Okay. Then just one other question I have is more out of curiosity. But if if a company in our space is sued and a reasonable court determines they violated the FDCPA, and maybe there's some fine or some requirement based on that judgment, is it then automatic that we would pile on, or do we? In other words, what I think I heard you say is that at that point they violated state law, right? And if that court has dealt with it, are we taking it up here and then putting an additional fine on?
That again, that's your jurisdiction. So essentially the way that we would move forward with that is, it would be essentially a complaint presented to me to summarize, advise
Okay.
you of what happened, what was the punishment put into that court of jurisdiction, how would that compare to our rules, cite the rule that it violates
Okay.
specifically for us, and then you all would be able to weigh whether or not further discipline would be required.
Okay.
That's your jurisdiction. But essentially, this ties us all together, right? I mean, there's
Okay.
now a federal database and then a state rules of conduct, and this is kind of tying them both together.
Okay, and I like that. I just want us to be careful not, maybe we'll take this up sometime if and when it happens, but if a court has already found that one of our members has violated and issued a fine, I don't really, personally feel like it's been dealt with and don't necessarily want to pile on more fines.
Absolutely. And that's completely within your jurisdiction.
Okay.
And as your legal counsel, I defer to your judgment on those matters.
Okay.
But this would essentially give us the ability, if there were circumstances that warranted. So I guess the classic example would here would be a collection service that, is hit for unlicensed conduct from sea to shining sea all across the country. We as a board may want to investigate and assess how many individuals within this state do they provide services to, which would be a direct violation of our licensing policies, and
Right.
whether or not you guys would like to look into that as well.
Good, Thank you for the clarification.
So our mics are wonderful, but only 4 can be on at the same time. So if you see that it doesn't turn on, that's because yours is still red, but we're good. Only thing I wanted to add is, this isn't really new. Our jurisdiction allowed for it. It just was worded in a funny way. So you've had the authority, and I think it's important in the case of a revocation, for example. If they are licensed here and there's something major that has happened, we would definitely want to revoke the license, or potentially, depending
Yeah.
the bad actor. Yeah,
Makes
thank you.
perfect sense. And the fact that this board ultimately can decide what to do at that point gives me, I feel good about that, because there are times where we will want to pile on, maybe revoke a license. There'll be other times we go, you know what, they got hit hard, somebody else dealt with it. Let's just let them know we're aware of it, but let's don't issue any new fines. And we could do that.
Yes, sir, absolutely. Okay, so those cover the differences in the rules from last time. We don't need to vote on those information, right? Okay. And then the final piece I want to go over with you, last time, the chair of the board brought up a question to me about where Tennessee law states as far as assignments and collection services go. We've had several complaints filed on the basis that a collection service had basically been assigned an account, and then the consumer stated, hey, this collection service is suing me. I don't recognize this collection service as an entity. I never took out a loan or received a medical service from them. And then basically a complaint is filed based on the ground that, hey, this company is suing me and I never engaged in business or received a service from them. This is wrong. Or the declaration, this is wrong. Tennessee law does allow a collection service in which it has received an assignment of indebtedness to bring suit in its own name. There are strict rules that apply, and the right has to be specifically given via contract assigning the account. So essentially, it's a contractual obligation. If, let's say, for instance, Hospital A decides that they're going to employ collection service X to process and collect their accounts, in order for collection service X to file a lawsuit against John Smith, collection service X has to have in the bill of assignment the hospital stating you have the right to bring lawsuit in your own name on our account. If
Okay.
it is so stated in that document, and that document is filed as part of the state court lawsuit, the collection service can bring suit in its own name for an account that it does not own, just simply an assignment. So Tennessee law does allow for that. Again, it's got to be in writing, and there are several other criteria that matter. They have to be represented by an attorney, so the collection service can't pro bono or represent itself essentially in a suit on its own name for an account it doesn't own. But yes, so Tennessee does allow assignments of indebtedness and a collection service to bring a lawsuit. And then there was a side question as to whether or not a collection service could combine accounts in a single lawsuit brought in state court. Tennessee law does allow for a collection service to combine accounts within the same lawsuit. However, it is a very sliver of an exception. So essentially, the underlying debts could only add up to a total of $500 exclusive of attorney fees, interest accrued on the account since they were turned over to the collection service. So the answer to the question is yes, they can combine accounts in a single lawsuit. It would practically, it's hard to do because you would have to have multiple accounts that add up to a value of less than $500. But essentially, yes, it is allowed, but it would be hard to do and would only apply to very small debts.
Okay.
Would those have to be from one creditor, or could they be from,
Tony, go ahead and press your mic. Thank you.
could they be from different creditors?
It could be from different creditors, but the cap remains the same. So total debts would have to add up to 500 or less, exclusive of interest, attorney fees, or anything like that.
Thanks.
Okay, so this is great information, and just so everyone knows, the reason I brought this up is I was heavily involved with a company headquartered in Colorado, and this has become a big deal in the state of Colorado, specifically for the largest healthcare provider in the state of Colorado, who's getting dinged by the media for litigation. And then the question of assignment became a class action lawsuit against the healthcare provider and the license collection agency. It just became this big mess. And the state legislature in Colorado had to kind of come back and put new laws in place to further clarify and define who could file suit. And they went as far as to say that, okay, if the agency files suit, that will work in Colorado. However, you also have to name the original creditor in the style of the case or somewhere on the complaint so that the consumer knows where the debt was originated. So there were some clarifications there. And it really has become quite a big deal there.
Absolutely. And Tennessee law is a slight step back from that, but obviously they require that the collection service file that bill of assignment within the case, which would disclose the original creditor that assigned the right to them. So that's the disclosure element underneath Tennessee law. So, Collection Service A can still bring a lawsuit, Collection Service A versus John Smith, without labeling the hospital in the caption of the case, but the case would be dismissed unless, as an exhibit to their lawsuit, they
The
provided.
assignment is attached on an individual, not a blanket assignment, but an individual assignment?
Well, you can only bring a lawsuit on a specified individual. So if there are multiple accounts turned over to a collection service, all to that same individual, then they can file a lawsuit against that person on those accounts. But it's only to one person. And if they wanted to combine accounts, now we're under the $500 limit that we just discussed. So like
Okay.
a medical bill, that would be tough to do.
Okay, well, where it got sticky in Colorado, this is a distinction I think we need to discuss, was that the creditor had issued a blanket assignment to the agency for all accounts listed with them. So they are assigning all accounts, and you can do whatever you want to with them, including litigation. And so it's part of their contract. It wasn't done on a per-case basis where, okay, Greg Swirsky's company wants to sue Chip Hellman for Hospital A, and now there's an assignment on Chip's accounts that goes as part of the complaint. So what was blowing up was this blanket, part of the argument was this blanket authorization to cover everything, because the provider didn't want to have to do it on a per-case basis. They said, let me just issue an assignment. Greg, we trust you. You've been working with us 20 years. If you think they need to be sued, we're going to give you the authority to sue anybody you want within our agreed-upon parameters. But in Tennessee, is it your opinion, I know it's probably not stated, but the assignment needs to be on a per-debtor basis?
I think that the blanket without speaking or becoming a general sessions judge, I believe that the blanket assignment document would probably suffice as long as it is filed as that exhibit, because again, you have the creditor identifying them. So, without
Okay.
putting any companies or hospitals on blast, if Hospital A in Nashville says, hey, this collection service over here is great, we like working with them, we're going to give you blanket assignments. Well, then when the collection service moves on a legal action against an individual, they still have to establish they have the right to bring that lawsuit. So they would need to attach the blanket assignment
it.
sheet, and then that person would see the hospital identified on the assignment document.
And a simple way to fix that would, in the style of the case, would be Greg's Collection Company versus Chip Hellman for Southern Hills Medical Center.
Yeah, I mean, you could do that. It's not required by Tennessee law as of now,
But
but
it
that
would-
attachment has to be included.
Okay, you still have to have the
Right.
attachment. Okay, thank you.
Yeah, absolutely.
Good, thanks. That's really helpful. Pardon me? I know, just don't want to do business in Colorado. Oh, yeah, right. Holy smokes. I mean, some of the laws they have there, it's crazy. We could talk
Be
about.
here all day.
Yeah. Well, I wanted to move a person to a salary position, and they said, well, according to state law, you have to bump them to $60,000 because the minimum salary someone can earn in this state is this amount. That's why they're hourly. And then next year it goes to 67.5, and then it goes to 75.5. And it's like, oh my gosh, so you don't put someone on salary because you're,
Automatic raises.
yeah. I mean, it's just, anyway, sorry. Rabbit hole. Squirrel.
Thank you, Chair. Any other order of business that the board has? None? Okay. I want to make sure that we address, as the board is aware, anyone that is here in person, which we don't have anyone participating, or through Teams is able to ask us questions, have an opinion on the agenda. I just want to make sure that no one participating online has raised their hand. John, if you could just confirm that we're good with our Teams meeting?
We are good. I don't show anyone with their hand raised.
Thank you. Thank you, members. That is all that we've got. We would entertain a motion to adjourn.
Motion to adjourn, anyone?
I move to adjourn the meeting.
All right, Lori. Second?
I'll second.
Jason? All in favor?
Aye.
Thank you so much, members. We are adjourned.